Congress shall make no law abridging the freedom of speech or of the press. So says the First Amendment. Does the freedom of speech include speech on radio and television broadcasts? Sure. But is that freedom as extensive as the freedom accorded to print, cable, and other forms of mass media? Oddly, no. Broadcast has for many decades been considered different in the sense that broadcasters occupy a scarce resource, the electromagnetic spectrum, frequencies on the spectrum. Not everyone who wants to be a broadcaster can be one, says the FCC, because the frequencies are finite. As a result, the Federal Communications Commission, an independent agency created back in 1934, has long taken the position that broadcasters are not just private entrepreneurs, but along with that license, they have public responsibilities and are public trustees of a sort. That they are therefore subject to public interest responsibilities. They can make a lot of money, but they also have to meet certain public interest responsibilities that go along with that license to operate on that particular frequency. And those responsibilities include obeying restrictions on some content put on some of their broadcast content. And that those content restrictions are subject to lesser judicial scrutiny than is government regulation of content of other media. The lesser scrutiny isn't strict scrutiny. It's sometimes called intermediate scrutiny. It's sometimes given other nicknames. What are the two big examples? The two big examples of content regulation of broadcasting are the Fairness Doctrine and the indecency rules. Under the Fairness Doctrine, remember that old thing? The FCC required broadcast licensees on radio and TV to broadcast, among all the other malarkey that they broadcast, to broadcast programming on controversial issues of public importance and to include opposing viewpoints. A great deal of discretion was left to the broadcaster as to how to pick these issues and how to pick the opposing viewpoints. And no one ever lost a license at the FCC for violating the Fairness Doctrine, although there were a lot of challenges. Licensees spent a lot of money complying with the Fairness Doctrine and reporting their compliance, and they probably aired a lot of content that they otherwise wouldn't have aired. They may have shied away from programming certain things as well, fearful that Program A might trigger a Fairness Doctrine responsibility. So the Fairness Doctrine existed for decades as a public trustee responsibility for all licensees, radio or TV. Now what about the indecency rules? Well, under those rules, the broadcasters were prohibited and are prohibited from airing content. I don't want to read this, but you know what it's about. Airing content relating to sexual or excretory activities or organs. If that content is in a context that's patently offensive according to community standards for broadcast. In other words, if the broadcast of that kind of material took place when there was a reasonable risk of children in the audience. This is the indecency policy of the FCC. that's implementing a federal statute in 18 U.S. Code 1464 that's existed as a ban, really, in 18 U.S. Code. It says there shall be no uttering of any indecent language on radio or broadcast, period. Well, the FCC was scared of that ban, didn't want to ban this, so interpreted that language and came up with an indecency policy. And, interestingly, left violence out, but put sex and excretion in. Okay. And along with the policy, implementing a ban. Along with implementing the ban through a non-ban, the FCC created a safe harbor that the indecent stuff was prohibited when the kids were likely in the audience between 6 a.m. and 10 p.m., but after 10 and before 6 a.m., let it go. Let it all, you can broadcast the stuff. Now, I don't know whose kids they're thinking about. Mine certainly never went to bed before like 1 in the morning. But anyway, the safe harbor for indecent expression begins at 10 and goes to 6 a.m. So the FCC thinks, okay, we got a nice policy that isn't too awful. We're not trying to implement the ban of Congress. We've kind of narrowly tailored it a little bit, and we're trying to protect someone. We're trying to protect children from hearing awful things. All right. Well, the fairness doctrine, the thing I mentioned first, was challenged by broadcasters in the 1960s as an abridgment of free speech. The Supreme Court, in a case called Red Lion, relying on the scarcity of the spectrum rationale, ruled that the FCC did not violate the First Amendment in imposing the fairness doctrine requirements on broadcasters. The court said, hey, it's not the rights of the broadcasters, but the rights of the viewers that are paramount. The court said the viewers have a right to receive suitable access to social, political, moral, aesthetic, and other ideas and experiences. And so the fairness doctrine was upheld under less than strict scrutiny. Fairness doctrine was upheld. Broadcasters outraged and angry. Now, in the 1980s, under the Reagan administration, the FCC under Reagan rescinded the fairness doctrine. They said, oh, Lord, we've got all this technology now. We've got more frequencies that we can jam on the spectrum. For various reasons, we're going to rescind. It's no longer necessary. Even if it's the right of the viewers, it's paramount. They're still getting a ton of stuff. And we're rescinding. And we've explained it for like 900 pages. So therefore, there was no admin law problem. It was not an arbitrary rescission because it had been super explained and footnoted and translated into multiple languages, for crying out loud. So it was not arbitrary, the rescission, and broadcasters rejoiced. However, the indecency rules are still there. They were challenged back in 1978. Yeah, in a case involving George Carlin. The famous George Carlin comic monologue, 7 Dirty Words. We should play it. Do we have time? Do you have it, Scott, on your phone or something? Okay. The 7 Dirty Words monologue of George Carlin was broadcast by a public radio station in California during the afternoon. And some father driving his little kid in the car blundered into it on the radio in the car. What is that stuff? And complained to the FCC. The FCC said, ooh, they're putting the 7 Dirty Word monologue of George Carlin in daytime drive time. So the FCC took mild enforcement action against the radio station. Didn't lift the license, but took some mild enforcement action against the station. The Supreme Court affirmed in a plurality opinion by Justice Stevens. The court said that the broadcast was indecent as broadcast. It had shocking language used during a time when kids were definitely in the audience. It could have been totally fine to air it at night when the kids were not reasonably in the audience, but in the daytime, yes. Indecent as broadcast. The court didn't mention the scarcity rationale for broadcast regulation. Didn't say, oh, you get less First Amendment rights because there's a scarce spectrum. But the court, Stevens did say, you get less First Amendment rights, broadcasters, for two reasons. That broadcast TV and radio are uniquely pervasive in the lives of all Americans. And second, that broadcast is uniquely accessible to children. Those were the two new rationales for lesser First Amendment protection. Justice Stevens wrote them down and said you get less protection from the First Amendment for these reasons, and this decision by the FCC about the George Carlin monologue on radio, we're going to affirm that. The FCC's taking a kind of a narrow approach to its statutory mandate, and under the circumstances on these facts and given lesser First Amendment protection, the decision holds. Okay, brings me to this case, and I've only got 2 minutes left. FCC versus Fox. I honestly thought when I was practicing media law in Washington a number of years ago that this whole thing about broadcast is different would go away soon. I never dreamed that all these years later, when I'm a tired old burnout professor, that's the same kind of law still exists. That broadcast is still considered different, either because the spectrum is finite or because this stuff about broadcast TV is uniquely pervasive in our lives and uniquely accessible to kids. I never thought that broadcast would ever continue to have lesser First Amendment protection. You know, back in the late 70s, everybody in Washington walking down the street, total strangers, would say that policy is going to go. With the change in technology, with the advent of cable, with the advent of the V chip and more parental power over what their kids can absorb, it just seemed like the broadcast is different model would go away. It didn't, though. And so here it is, 2011, I think, and broadcast is still considered different under the First Amendment, or at least the Supreme Court hadn't done anything to undo that approach. What's different is, you know what's different? The FCC has expanded its indecency mission. It's now not just enforcing against the verbal shock treatment of something like the George Carlin monologue. Bing, 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 bing. If we played it now, you'd feel that kind of, you'd feel something. We play it. You ought to play it, see what you feel, but you'd feel something. Now the FCC doesn't go just after that, but it's going after other stuff. Fleeting expletives, like when Cher gets some award on a live TV program, as she did in 2002. Billboard Music Awards, broadcast by Fox before the safe harbor. She gets up there and uses the F word. The next year, that paragon, Nicole Richie, who I don't even know what she looks like, she gets up and uses the F word and the S word on the same music awards show. And Fox is broadcasting this, but doesn't have the 30-second delay technology plugged in, and so the whole world hears it and is stunned. Okay, the FCC, under the urging of people like Senator Rockefeller, say we're going to come down hard on this stuff. Even if it isn't the verbal shock treatment, it's fleeting expletives, and we still think that violates our policy implementing that old statute. So the FCC enforces against Fox for that. And then there's a case involving NYPD Blue where the little kid goes into the bathroom and sees the naked lady. I think it's his father's girlfriend or something. And the FCC said, well, that wasn't a fleeting, unscripted expletive. That was that's scripted nudity. And the FCC ruled, enforced against that, against NBC for that segment in an old NYPD show. All right, look, what's the punchline here? the FCC's current policies were challenged. The Supreme Court held in 2009 no admin law problem. As the FCC changed its policy, they met all the wonderful requirements of administrative law in explaining their thinking and changing their practice. So I'd rather talk about the admin law problem, but that's not what Scott wants me to talk about. The FCC was an admin law genius and got it all right. But now we're back in the Supreme Court as to whether or not the new policy is constitutional. So therefore what? The court has an opportunity to roll back the old stuff. The court has an opportunity to say, broadcast isn't really different anymore. The spectrum might be technically finite, but the spectrum, there are tons more frequencies than there were in the 60s due to advances in technology and also due to the shift from analog to digital. You can stack these stations now. So the scarcity rationale, the court has an opportunity to say, is obsolete, is no longer good as a rationale for treating broadcast differently under the First Amendment. And the court has an opportunity to say that stuff about uniquely pervasive in American lives, so was Jaws, so any epic movie, Titanic, that everybody saw 17 times and hummed the tune on the way out. That was uniquely pervasive in American life, so maybe that rationale doesn't fit either. What about unique accessibility to kids? Is TV still, broadcast TV still uniquely accessible? I don't think the court is really going to be too enamored of that rationale, since they just ruled, 7-2, I think, in the video game case last term about protecting children and whether that was an adequate governmental concern. So look, what's going to happen I'm always wrong when I predict, so why not be wrong again? Here's what I said. I think the court will duck the larger question. I think they'll duck the larger question on whether broadcast is different or not. They've always ducked it. Why not keep ducking it? I think, though, they'll say something like this. We need not even decide that, because even if broadcast isn't different from the other media, and even if strict scrutiny applies, this thing flunks strict scrutiny. It's not really narrowly tailored, and the governmental interests are weak, given the advent of new technology and other circumstances that kind of change our whole view of these things. So we'll see. Thank you.